We decided is that it would be helpful to sort of have problems addressing sovereignty issues. And what we elected to do was to use treaty language and look at treaties in Montana of Montana tribes and compare how the courts have looked at fairly similar language in treaties and reached very different conclusions as a way of sort of explaining and exemplifying the difficulties in Indian law when you're relying on courts to interpret in treaties when they aren't consistent. So you have a change in the recent Supreme Court, and recent for Supreme Court is like last 20 years, where it used to be that tribes were recognized as retaining all those sovereign powers unless they had expressly given them up in treaties. And then you had the Supreme Court decide, in a case arising out of Montana, Montana v. U.S., that tribes only had those rights given to them in treaties, which is a totally different approach to Indian law. And of course, there was no reasoning authority or anything cited for that shift there. So now tribes are dealing with the fact that they have to demonstrate that that right was expressly retained or implicitly retained by some action or something with the federal government. And it's a challenge. It's Montana v. U.S. is the case. And I think that one came out in, I think it's 85. The subject, there were two subjects. It grazes off of Crow, and the issue was who owns the bed and bank of the river going through Crow, and also whether the Crow tribe can regulate all, in this case it was fishing primarily, on those rivers. And the treaty language set the boundary for the Crow reservation at the midpoint of that river. And so the tribe's argument was, it's set at the midpoint, so we must have control over at least part of the water because of the language in the treaty. And the Supreme Court said no. When Montana became a state, the bed and banks went to the control of the state of Montana, as opposed to looking at the treaty language. And they also said that the tribes therefore could not regulate the fishing on it except for members. Or I think they use the term, I don't think they use the term member, I think they actually say Indians, so I think it's broader than just member Indians. I think it's any Indian on the reservation. But they pretty much eliminated the regulation of non-Indian fishing. Now that's very different than what you have up at Flathead, because the Hellgate Treaty has very different language, and on Flathead, all the fishing is regulated by the tribe. And that's because of the very strong language in the Hellgate Treaty that gives the tribe exclusive control of the waterways within the reservation boundary. Well, there's actually 3 different treaties that affect tribes in Montana. There's a Fort Laramie Treaty, and there's several Fort Laramie treaties. There's 3 different Fort Laramie treaties, and then there are individual treaties. So Crow comes under the Fort Laramie Treaty, but it also has a treaty for the Crow tribe that was entered into it. So you have to read those 2 in conjunction with each other. And the Fort Laramie Treaty is what I refer to as a military treaty. So it's more establishing boundaries, looking at land issues, less concern about recognizing or articulating those powers, rights of tribes. That's very different than what you have under what are called the Stevens Treaties, which are the Blackfeet tribe and the Confederated Salish and Kootenai tribes, where those are Stevens Treaty, Governor Stevens entered into those agreements, and he has a much more expansive view of at least enumerating those powers that tribes are retaining under the treaty. And it makes a huge difference in what those treaty rights are. So hunting and fishing on Flathead is very expansive. You can go off reservation to hunt and fish, those historical lands. And for example, the recent hunting around the Yellowstone National Park by both the Flathead tribe and the Nez Perce tribe are because of their treaty language that allows that. Crow's language just says hunting and fishing as long as game is available, and now this is where I never can remember, I think it is under Crow, the land is unoccupied. One of them is unoccupied and one of them is unclaimed. And I think think the Hellgate Treaty is unclaimed and the Crow is unoccupied. But the courts have interpreted those two provisions, and the provisions are unoccupied or unclaimed. The courts have interpreted those two provisions very differently. And that's sort of the whole point of the exercises that we have in there, is to have students think about, well, if you are a tribe and this is being translated to you, what do you think the difference is between unoccupied and unclaimed? Do you think that was explained to the tribes? And were they different terms at that time? Did they have different meanings? And how was that explained to the tribe? So those are the main examples that are used to sort of flesh out how sovereignty comes into play currently, looking at those treaties.